it seemed innocuous at first. That language, oh, we're just making sure we're going to do the right thing. That innocuous language was giving cover to a profoundly corrupt action, to forcing a foreign country to do a sham investigation into your political opponent, or else we're threatening your literal safety.
Welcome to Law and Chaos. Today, we've got a deep dive into the president's ability to seize control of the budget from Congress. TLDR, he cannot. But not everyone grew up watching Schoolhouse Rock, so it looks like this is going to become a thing. We got a lot to cover, so let's get after it. Hey guys, I'm BlueSky, and with me, as always, is Andrew Torres. Andrew, how are you?
I'm as good as anyone can be 1 week into the Trump presidency. How you doing?
It's rough.
Yeah.
I'm not going to bullshit you guys. This is, following the news, it was rough. But look, I mean, this is what we do. We're going to continue to do it. We will be here.
Yeah. And look, we got a great show for you today. We're going to get into the weeds on impoundment, and we're going to talk about the legal aspect, but this is another component of Donald Trump's plan to consolidate all of the power of government in his hands. And so the way it works is that when Congress has passed a budget, which, lest we forget, is a law, if Congress allocates money for things that Donald Trump doesn't like, things like infrastructure or green energy or protecting women's rights, he's going to instruct his subordinates not to spend that money. You may recall this exact same playbook from 2019 when Trump illegally withheld funds Congress authorized for Ukraine to force President Zelensky to, do us a favor, though. It is wildly illegal. It's probably also unconstitutional. And we got an expert to talk about what it all means and why.
But first, docket alerts. Dun, dun, dun. All right, so
bumper.
let's start. Yeah, let's start with what's obviously the biggest news. Trump has begun a purge of the Justice Department, firing everyone who worked on the special counsel investigations of his crimes and announcing an investigation into their conduct. That is, he's going to investigate the lawyers who worked at the Justice Department. Actually, that's two separate crazy things, and we should be careful to kind of disaggregate them, if only so we can be mad twice.
Or forever, but yeah.
Yeah, no, I will be. Okay, so first of all, Acting Attorney General James McHenry sent these career lawyers a termination notice that said, "You played a significant role in prosecuting President Trump. The proper functioning of government critically depends on the trust superior officials place in their subordinates. Given your significant role in prosecuting the president, I do not believe that the leadership of the department can trust you to assist in implementing the president's agenda faithfully." And BT dubs, the function of the Justice Department is not to implement the president's agenda.
Right.
The function of the Justice Department has always been to prosecute criminals, right? It's a gross acknowledgement of the fact that this is going to become a political
that we've elected criminals. Yeah, right.
Right. I mean, look, he's already pardoned all of the people convicted of obstructing clinic access, including people who, chained themselves to chairs, blocked women in, did other violent acts, stole fetuses. There is actually a woman pardoned who had stolen fetuses in her apartment.
He pardoned his insurrectionists, every last one of them. I mean, but I should let you finish or we'll never get to our interview.
Yeah. I mean, look, this is an attack on lawyers, really good lawyers, who did their jobs. And maybe they have civil service protections. There are certainly lawyers like Mark Zaid who are, offering to represent them in suits, civil service suits. We'll have to revisit that one. I don't want to comment on the strength of those cases without investigating further. It's bad. At the same time, this is the second thing, interim U.S. Attorney for the District of Columbia, Ed Martin, is launching a, quote, special project to investigate the attorneys who brought 1512 charges against the January 6 defendants.
This is just so offensive, right? Those 18 U.S.C. Section 1512C charges were for obstructing or impeding an official proceeding, right? The joint session of Congress to count the electoral votes and recognize Joe Biden as president, right? Of the more than 1,400 defendants who were prosecuted in connection with January 6th, only 247 were charged with 1512C obstruction. these are the folks, right? This were the guidelines handed down by the DOJ. These were the people who actually broke into the Capitol with one exception. That was Slizardo Stewart Rhodes, right? He's the guy who coordinated his crack G.I. Joe commando unit to invade the Capitol. But right, like, these people are the worst of a very bad bunch. And the decision to charge them under 1512 was completely in line with how the DOJ and every court before and all but two after had interpreted that statute, right? But as we know, in the summer of our discontent, the Supreme Court endorsed a super idiosyncratic interpretation of Section 1512 in a case called U.S. v. Fisher that we've talked about a lot. Basically, Chief Justice Roberts said, if you don't also destroy a piece of paper while obstructing an official proceeding, the conviction doesn't count. So, of course, that helped out Trump. That was the point. He was facing a 1512 charge of his own. It also threw into question the nearly 200 convictions and guilty pleas that the government had secured before SCOTUS changed the rules on them. Although many of them were going to be upheld anyway because, as we've said, these were seriously bad dudes who got convicted of other felonies as well, right? So their sentences were going to stand. But I want to be pellucidly clear here. The inference that Martin wants people to draw is that a weaponized, out-of-control Department of Justice used a law that they knew was improper just to target Trump's buddies, and that is 100% a lie. The Department of Justice followed their long-standing understanding in good faith of this statute until, make it up as we go along, John Roberts changed the rules.
Yeah, and by the way, Ed Martin, he was at the Stop the Steal protest. That's the acting, the interim U.S. attorney in D.C. He spoke at the Ellipse. He pals around with Mike Flynn. He basically sent a preservation letter to everyone who prosecuted a January 6th defendant. He says he's going to get to the bottom of how this great failure of our office happened.
I thought these were the folks who wanted immunity for official actions so that, while government officials did their job. Sorry, that's only the president. Anyway, thanks, Chief Justice Roberts. You bent the law to accommodate these insurrectionists, and now it's going to destroy the entire Justice Department. Looking forward to that.
Yeah, the outrageousness of this should be clear. But maybe what isn't clear is the pointless destruction of the Justice Department, right? They are getting rid of the most experienced practitioners. They are turning this into a partisan organ staffed by hacks.
Mm-hmm.
This is Weimar shit.
Yeah, it really is. So, okay, well, let's keep one eye on the helpers. Today, a coalition of Quakers in Virginia, Maryland, Massachusetts, and Pennsylvania sued the Department of Homeland Security over its newly enacted Trump policy rescinding protections for houses of worship, schools, and hospitals, and allowing ICE to enter them to conduct raids. Previously, it was the policy of the government not to intrude on churches, synagogues, mosques, etc. to snatch up people for deportation. The plaintiffs claim that this change violates the First Amendment right to expressive association and that the abrupt shift in policy violates the Administrative Procedures Act. We'll link to the docket in the show notes, right? I mean, that's obviously a lot.
Yeah, we'll hope to get to that case later. There are so many cases being filed.
Yeah.
But okay, before we get to the main show, let's have a little non-Trump palate cleanser, courtesy of Blake Lively and Justin Baldoni over their 2024 film, It Ends With Us. The parties' dueling lawsuits in New York are pending consolidation before Judge Louis Lyman, who just got rid of Rudy Giuliani's collection action brought by the Atlanta poll workers Ruby Freeman and Shay Moss.
Yeah, that guy rolled a 1 when it came to case assignments. But look, it turns out that assignment is going to be relevant because the same team of lawyers who represented Freeman and Moss, that is lead counsel Michael Gottlieb from Coat Factory law firm Wilkie Farr, also represents Blake Lively and Ryan Reynolds. And I just want to give a little bit of my impressions here as a practitioner because, look, Gottlieb is rightly feeling like he just earned himself a ton of credit from Judge Lyman. He did, right? And what he had to do in the Rudy case was document in excruciating detail all of the myriad ways in which Rudy was not complying with the law and the court's many, many orders. And Gottlieb did that. And, I respect a man who can get in the weeds with the details, right? But he's running the same playbook here because it's the same judge. And the second time might not be the charm, my dude, right? Like, judges do want to hear about the other side's Giuliani level misconduct, right? But by and large, they do not want you to run to them 3 times a week complaining about service of process.
Right. We talked about this on Friday's show. But essentially what happened is that Baldoni's lawyer, Brian Friedman, who, as we said, he's an experienced media lawyer from California. He is not Joey Bada Bing Camerata. He asked for a brief extension of time to answer Lively's complaint. And yes, like in the bickering toddler sense, he started it. He was such an asshole about not agreeing to execute a waiver of service, and he like sent the process server out, and you know, he was a jackass. But like when the other side calls you up and asks for a modest extension of time to answer the complaint, like you just say yes. You don't act like a jerk.
Yeah, that is exactly right. And look, you know, you mentioned Joey Bada Bing, and man, I'm going to miss that guy.
I would caveat that by saying that I have no confidence that Rudy Giuliani can successfully extricate himself from this case. I mean, remember, this is the guy who like fell backwards out of bankruptcy and then fell back in because he couldn't fill out the paperwork. So like
he tried
a settlement agreement.
He tried to stipulate in front of Judge Howell. Yeah, no, if anybody can fuck this up, it's Rudy. Fair point.
Yeah.
But okay. Gottlieb even granted Rudy a bunch of courtesy extensions and accommodations, rescheduled depots, held them over Zoom, that sort of thing, as long as it didn't affect the discovery or the trial deadlines, and he only really pushed back on the obviously bad faith stuff.
Yeah, but it doesn't look like it's really playing with Judge Lyman.
Yeah.
Judge Lyman today was like, no, I'm granting the motion for extension of time. And, you know, a couple of days ago, he said, I think I'm going to consolidate these cases. He put out a order to show cause why the cases shouldn't be consolidated, which strongly suggests that he's like, I'm not doing this twice. Right. These cases go together. Just, you know, cut the shit. And I'm not interested in, you know, policing your sandbox spat.
Yeah.
But even as this, like, dumb kerfuffle is going on, there's a slightly higher stakes kerfuffle about Gottlieb trying to stop Brian Friedman, that's again Baldoni's lawyer, from shit-talking Blake Lively on podcasts and whatever.
Yeah.
The argument here is that Friedman is violating Rule 3.6 of the New York Rules of Professional Conduct, which prohibits a lawyer from making statements to the press that, quote, the lawyer knows or reasonably should know will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter, which is like, don't poison the jury pool.
Yeah, and that's right. But subparagraph D of the same rule says that a lawyer can make statements to the press to protect his client, quote, from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client, which, you know, is why you see lawyers on TV talking about their cases all the time. It's an exception that, you know, in my experience, swallows the rule. So brass tacks. At this very early stage, but before, you know, the parties have answered, before there's been any discovery, I just don't see Judge Lyman weighing in on, you know, as you put it, Liz, who started it, right? Like, I think Friedman probably did, right? Like, but I think he has a non-frivolous argument that says, hey, it was your client, Blake Lively, who went to the New York Times, right? Like, and I'm just responding to that. And so, to be clear, I think what Friedman is doing is scummy. It's not how I practice law. It's not how I would encourage anyone to practice law. But like, a gag order is serious business, you know? Like the comment to Rule 3.6 that applies here is pages and pages long, right? It's extensive about balancing the public's right to know against the need to protect the integrity of judicial proceedings. And, you know, as we learned from the Trump cases, right? Like, the rationale for a gag order is strongest in the criminal context rather than, you know, civil lawsuit between, you know, celebrities, right? I don't think Judge Lyman is going to issue a gag order here.
Yeah, I would tend to agree with you only because there's such a strong First Amendment protection.
Yeah.
But I guess I would counter you because it's not just that they say he's violating Rule 3.6. Her lawsuit says you retaliated against me for filing a sexual harassment complaint by trashing me in the media. And here you are trashing me in the media, which is retaliatory in and of itself. I mean, I understand. I agree with you that the First Amendment complaint is, you know, the First Amendment protections are probably going to mean that she doesn't get her gag order. But her argument is the damage here is you retaliating against me. And Friedman is Baldoni's agent continuing that campaign of retaliation, which violates their contract and, you know, violates California's law, which says you can't retaliate against somebody for filing a sexual harassment claim. I don't think it's going to work, We really, really strongly disfavor prior restraints in this country, but I don't think it's a crazy argument.
Oh, I agree with that 100%. And in particular, I think the contractual argument is really strong. I don't think it's going to wind up at a gag order. So I think we're at the same place.
Yeah. Okay. All right. It is Tuesday, so let us thank our new subscribers.
Yeah. On Substack, thank you to Christine Duffy, to EJC, to Amy Krikorian, James, John, Adam Robinson, Sarah, and Jennifer Sigler.
And on Patreon, thank you to Kelsey Jorgensen, Kevin Olinger, Natan Patinsky, Rob Bauer, Eric S. Carpenter, UIC Law Loves OA, M.I., Corbin the Dog, Joshua Mulligan, Ted Ross, Dan Hayes, Lisa Tome, Colin, Mikiel, Addison P., and Cindy Byrne. Thank you, guys. Couldn't do it without you. All right. If you would like to get a shout out and, more importantly, support our work, you can do that at patreon.com/lawandchaospod or lawandchaospod.com. And if you do, there will be no ads for you today or ever. But if not, please enjoy a quality moment with our sponsors. And we're back. With us today is Bobby Kogan, Senior Director of Federal Budget Policy for the Center for American Progress. He formerly served in the Biden Office of Management and Budget, and before that, in the Senate Budget Committee working for Democrats. Okay, Bobby, thank you so much for being with us today.
Thanks so much for having me on.
All right, let's get to it. Let's start at the beginning. Bobby, what is the Impoundment Control Act?
Sure. So the Impoundment Control Act is a law that says you must spend money that is appropriated. But before we get there, I think it's the executive branch must carry out appropriations laws, and carrying them out in this case means that you must spend the money that is given. You must prudently obligate any budget authority. You cannot, through action or inaction, it's like the three laws of robotics. You must make sure you can't you can't not spend you can't not allow something to be obligated through inaction. You have to go about spending it. But before we get there, it's actually really important. One of the misconceptions you see in the media around this is lots of folks will say, oh, you have to spend this money because of the Impoundment Control Act. And that is not true. Prior to the Impoundment Control Act, there were tons of cases in the Nixon administration. They all said, including one Supreme Court case, they all said you have to spend the money. So the Impoundment Control Act codified what a lot of court cases had said, but it's not the reason you can't do it.
Right. And I think it's axiomatic. Most people understand, even if they're, not lawyers, that Congress under the Constitution has the power of the purse. Congress sets the budget and gives the money to the executive branch to disperse or obligate. Is that the term that you used?
Yeah, so the Congress will appropriate budget authority. Budget authority gives you the legal ability to incur an obligation on behalf of the United States government. Then there's this step called apportionment, which ends up being very important to impoundment, but we'll skip over for now. Then the agencies will go about obligating, signing contracts, that sort of stuff. They end up putting the money actually on the hook. And then the money will be spent out pursuant to those contracts. That can come way later. So you imagine let's say you get $10 million of budget authority to build a bridge. It might be 1 year money. They say you have 1 year to go about using this money. Using doesn't mean spending, it means obligating. So you can then sign a contract. Liz, your construction company, which you're running apparently, we sign a contract. They say, I'll pay you $1 million now and the remaining $9 million upon completion. We've just obligated all $10 million of that. $1 million is going to be spent now, and then the other $9 million will be spent eventually. But as soon as that's locked in, now the government is legally on the hook. And it's that thing that the Impoundment Control Act is making sure this money is obligated kind of on time. You're not allowed to go about stopping obligating.
Well, and let's talk about why this is a political issue, right? Because the issue that's before us now with President Trump and historically with President Richard Nixon that led to the passage of the 1974 Impoundment Act is the question, can the president, who is obligated to take care that the laws are faithfully executed, when say, $1 billion is designated to be spent by an executive branch agency, simply say, no, we're not going to spend the $1 billion. Do I have that correct?
Yeah, I mean, I would say in its simplest term, an impoundment is any action or inaction that precludes federal funds from being obligated or spent either temporarily or permanently. And
Good.
they want to argue that all of this budget authority is a ceiling rather than a target. You are always allowed to do stuff more efficiently. If you find a way to do it more efficiently, that's fine. And in fact, that's one of the reasons given for legal pauses inside of the Impoundment Control Act. But the whole kind of debate here is that these folks want to argue that they don't have to spend all of it. Congress gave them the option, right? That's kind of the argument behind all of this.
Okay, I want to just drill down on something that you said, because what you said was the Impoundment Control Act kind of codified or made clear a constitutional responsibility, right? That the reason that the executive branch must spend the money, must obligate the money, is not because of the Impoundment Control Act. It's because of the Constitution. And it was true even before the Impoundment Control Act was passed. And the Impoundment Control Act was passed because of the, source for so much ignored precedent in this Trumpian era. It was because of Richard Nixon, right?
Yeah, that's exactly right. So Nixon impounded tons of things. He impounded public works money. He impounded, I think, HRSA money, but I'm not 100%. Anyway, he impounded HHS money. He impounded Department of Education money. He impounded Highway Trust Fund money. He impounded tons of things because he didn't like the policy. And in order to sue, you had to find people who were harmed, and plenty of cases were found to be non-justiciable. But many of them, they found people who correctly had standing, and they went before the courts. And in every single case that was decided on the merits, Nixon lost. Nixon lost every single case that was decided on the merits before the Impoundment Control Act existed. People would look at the appropriations law. Sorry, the judges would look at the appropriations laws. They would look at the authorizing statute. And in a lot of cases, the statute, you take Train versus New York, which went to the Supreme Court. They said, yeah, the authorizing statute is actually completely clear right here. It says that the money has to go out in this very specific way. You're not allowed to just not do it, because all of a sudden the folks who were supposed to, the states or whatever in that case that are supposed to get the money are not getting the money.
Well, in fact, Nixon went to his Office of Legal Counsel, to a lawyer named William Rehnquist at the time, who, we later know from the Supreme Court, and said, opine as to whether presidents have the authority to impound funds. And Rehnquist, in a rather shocking departure for OLC memoranda, which, usually just spit back, yes, the person who hired me, I am going to write a memo saying, the conclusion you want me to reach. Rehnquist said, no, you absolutely don't have the right to impound funds. And in fact, if we can find plaintiffs, you mentioned cases that were non-justiciable, if we can find plaintiffs, we think courts will fashion remedies, right? Like this is not just an abstract principle, right?
Yeah, that's right. And in fact, actually, I'm not actually 100% positive. I would assume that this was around last time, but if it were going around this time, we have the Court of Claims. The judgment fund has unlimited indefinite budget authority. So in the Nixon cases, they just said, okay, release the money. But if the money lapsed and somehow you didn't get the money, the Court of Claims would make you whole, right? And there was a court case a couple years ago where the judgment fund, it was ACA risk corridors, reinsurance. It's one of those things, and I can double check and get back to you. But the payments, kind of mandated in the ACA didn't go out. They sued. They said, hey, I'm owed this under the law. And then the Court of Claims said, yep, you're right. Here's your money. Right. So if you're entitled to the money, you will get the money one way or the other.
Okay, well, I know somebody who might disagree, right? So if Richard Nixon is a 3, let's talk about Russ Vought.
Yeah. Well,
that was a pause.
Pregnant pause.
I'm trying to be diplomatic here.
I mean, you don't have to. We never are.
This is not law and diplomacy.
Yeah. I mean, Russ Vought has a very radical.
Am I mispronouncing it when I say Vought? Is it vote?
I believe it's vote. Lots of folks say vote. Lots of folks say vote. If you go and you watch his confirmation hearings, most of the people say vote in there.
So yes, again, you don't have to be diplomatic. I'm pronouncing
It's a
it wrong.
funny
That's
name
fine.
for a totally undemocratic person. But all right, so tell us who Russ Vought is.
Yeah. So Russ is a presumptive, is a designee to be director of OMB. He was acting director. He was deputy director of OMB and acting director of OMB when Trump illegally impounded the first time he was president. And then after that, despite leading a corrupt and illegal impoundment over Ukraine funds, he was then confirmed and so then was director of OMB. But importantly, for this, Russ Vought was the guy who oversaw the illegal impoundments last time. He has said 1 million times in public that they will impound again. He wrote the section of Project 2025 that was all about messing with apportionment in order to do impoundment. And now he's, and he got 1 million questions in both his GAC and Senate Budget Committee confirmation hearings about impoundment, and he's going to oversee Trump's impoundment. In fact, we had some day one executive orders that are illegal deferrals.
Okay, let's stop a second and remind the audience, because not everybody's going to remember what Russ Vought did with respect to the Ukraine allocation to impound it in the first Trump administration. So you want to walk that back for us?
Yeah, definitely. Before I do, we now have to talk about apportionment, because that is
All right.
a central part
Sexy
of
time.
all of this. I'm sorry, we have to talk about boring
No,
budget
it's good.
execution. But
No.
so the first step to spending money is normally Congress will authorize. You don't have to authorize. If you just appropriate, that is deemed to be an authorization. But normally Congress says, okay, you're allowed to spend money. And if you do, you're allowed to spend money on these purposes. And if you do, it's going to work out this way. Then Congress goes about actually appropriating the money pursuant to that authorization or creating the authorization at the same time. The next step you would think would be signing contracts, but it's actually OMB will apportion the money. So that is to say, OMB, the Office of Management and Budget, it's inside of the White House, right? They're the various agencies, but OMB is inside of the White House. So the White House will say, okay, cool, here you go. The initial kind of pre-apportionment dates back to the 1871 Anti-Deficiency Act. It's been amended and now we have apportionment living inside of this, but kind of the proto version dates back to that. And the purpose of apportionment is to make sure that money goes out the door on time, not for policy reasons. It's not because you like or don't like this money. It's to make sure that it goes out in schedule. So what happened during the Civil War? Sometimes the Army would use all of its money in 11 months and then say, okay, we're done for the next month, unless you want to give us more money. And maybe give us raises at the same time and some better stuff and, whatever. So apportionment is, it'll take a simple program. Imagine a program that is $1 million a month. So 12 million a year, and it's just very uniform. You would apportion every quarter, every 3 months. You'd be like, cool, here's another 3 months. Here's another 3 months. Here's another 3 million. Here's another 3 million. Here's another 3 million. Yes, Congress appropriated 12 million. Yes, the president signed that into law. But before the agency is actually allowed to go about obligating, OMB needs to formally release that money. And that is, again, the purpose of this is to make sure that they're on track to not use it all too quickly and also not use it too slowly. You don't want to end up in the case where you've run out of money in the final month. You also don't want to be able to get to the final month and say, oh my God, we've only used half of it. So it is literally just about making sure the money goes out in a good period of time. But really critically, you cannot, even if Congress said, here's the money and the president signed it into law, if OMB holds up that apportionment, you, the agency, may not go about obligating the money. And while the Impoundment Control Act has no penalty if you break it, so it's illegal to not spend money.
So, but before we get to the ICA, if I understand then, essentially what you're setting up is that the executive branch has legitimate ways in which it holds on to funds that are allocated to be spent right through the allocation process. But that's always historically been distinct from efforts to impound funds, right? To maliciously withhold that spending.
Yeah, you are not allowed to use apportionment to preclude money from being obligated. It is not for that purpose. It is in fact the opposite. The purpose of apportionment is to make sure that it's going to go out on time. You are not allowed to do it. I have to set this all up, but you have to set up like their mechanism to explain why what they did was so bad. But yes, the apportionment process is about getting money out on time. You are not allowed to change it for policy reasons. It's only for kind of technical budget execution reasons. But the key linchpin here is that if for whatever reason, whether legal or illegal, there's something wrong with the apportionment, and so all of a sudden you aren't apportioning the money, you may not obligate. And while not obligating is an ICA violation, there is no penalty for violating the Impoundment Control Act. But there is a criminal penalty for violating the Anti-Deficiency Act. So
Oh,
all of a
interesting.
sudden, it says to the agencies, even though you must spend, you may not spend or you're going to jail. So this is the backstop for how we get to what happened last time.
Mhm.
We appropriated money for Ukraine in a bunch of different ways, but the one that GAO ruled on was this DoD money for Javelin missiles. Now, really what happens is we give them money, they buy our Javelin missiles, and then we replenish our stocks, and so it's really for us. But it's easy to just think about it as it's money for them to get Javelin missiles to
Uh-huh.
help protect against a potential future Russian invasion, which obviously happened. At the agency level, DoD puts an informal hold. So this is an ICA violation because you're not allowed to kind of defer money.
Let me ask what you mean by an informal hold. Is that like a technical term, or is it just mean that they kind of went in there and said, don't do it in an off the
Yes,
books way?
that's right. So what
Okay.
what I'm going to call this, and what better people than me call this, is a soft impoundment.
Okay.
It's where the agencies kind of just pause.
Uh-huh.
It is illegal, but if you seemingly have an innocuous reason, you say, oh, well, we're just making sure that we're doing this efficiently and we want to
Hmm.
make sure that it's going to the right people and everything. People tend to not look too much into it, as long as the money eventually goes out. So there's a soft hold, and then Ukraine starts getting antsy. Zelensky is newly elected, and then he has a call with Trump. This is the perfect phone call. There's heavy
Hmm.
quotes for folks listening. This is heavy quotes around the perfect phone call. This is the no quid pro quo, which is of course actually a huge quid pro quo, where the president said,
First, you got to do us a favor, though.
yes, I'll release the money, but I want you to do me a favor, though. And on that day, it switches from a soft impoundment to a loud impoundment. On that day, it switches from an informal hold to a formal hold.
Now, what happened that was that transformation?
Yeah. So no longer was it just the agency doing an informal hold. Now OMB messed with the apportionment.
And that was at the express direction of then President Trump.
Yeah, I mean, or maybe Rust vote, right? I mean, but on that exact day, on the day that he has the day that Trump has this call with newly elected President Zelensky, they then go and change the apportionment. The money has already been apportioned, right? They already said, okay, here's the money, go about doing it. The agency just wasn't. But now they put a footnote onto it, and let me dig up the footnote. So the first footnote, they end up changing it many times, but the first footnote says amounts apportioned but not yet obligated as of the date of this reapportionment for the Ukraine Security Assistance Initiative are not available for obligation until August 5th, 2019, to allow for an interagency process to determine the best use of such funds. Based on OMB's communication with DoD on July 25th, 2019, OMB understands from the department that this brief pause in obligations will not preclude DoD's timely execution of the final policy direction. DoD may continue its planning and casework for the initiative during this period. So there are a couple key phrases here, but I'd be remiss if I didn't point out what is the purpose of all this? What was the quid pro quo here? The president said, I want you to do me a favor, though. And what was that favor? He wanted Zelensky to fabricate dirt, create a sham investigation to fabricate dirt against his political opponent, right? He was extorting a foreign nation into helping him with his election.
Okay, hold that thought, because we're going to go to an ad break and we're going to come back and we're going to talk about that. And then we're going to talk about Trump's current executive order. So thanks, Bobby Kogan. 1 second. And we're back. Okay, Bobby, tell us again about the footnote and the Ukraine allocation.
So there are a couple key phrases. Number one, they say they're going to determine the best use of such funds. That is on its face, is a legitimate reason to pause. So what they've done here is they've used an innocuous seeming footnote for an actually very malignant thing. We only know because we got all the information, eventually, that this happened on the day of the meeting. But if you just say, oh yeah, we're going to pause just to make sure we're going to be using these funds well, that's a legitimate reason to kind of give this sort of pause. And so one of the things that's so nefarious here is that they use something that seemed legitimate to disguise something that was in fact profoundly corrupt. Another key thing to pull out from this is that they say, based on communications with DOD, OMB understands that from the department that this brief pause in obligations will not preclude DOD's timely execution of the final policy direction, right? They say, don't worry, we'll still have enough time to get it out before the end of the fiscal year. Fiscal year ends September 30th. So they say, oh yeah, we're pausing until August 5th, but don't worry, we'll still have enough time. They end up pushing it back past August 5th again and again and again. I think, I can't remember the exact day that it ends, sometime in the middle of September. But that line, we understand from DOD that we'll have enough time, eventually drops out. So they eventually no longer are saying, don't worry, we'll have enough time. And you start getting frantic emails from DOD to OMB saying, please release the money. We are really worried we are going to be violating the Impoundment Control Act if you don't release the money.
Oh, I see. I didn't realize that it was going to implicate DOD. Okay.
Because DOD is in trouble for violating the Impoundment Control Act. But again, and this was what was so important about this apportionment stuff, is that while DOD has an Impoundment Control Act violation on its hands if they don't spend, they have an Anti-Deficiency Act violation on their hands if they do spend, right? Okay. And they go to jail. They have a criminal penalty for going and spending. So what did they do? This is all a way of taking power away from the agencies and centralizing it inside of the White House. All of a sudden, the White House says, you may not carry out the law or you are going to jail. And what's so to kind of further this, traditionally this apportionment was done by what are called the DADs, who are career officials. In every administration, except for the Trump administration, these apportionments were signed by career officials. In the Trump administration, they switched that to being the politicals, the PADs.
And that was right out of Project 2025. That was it. That was a chapter of Project 2025, which I believe was authored by Russ Vought himself.
That's exactly right. Russ Vought's section of Project 2025 says, let's go back to doing that so that we can centralize power inside of the White House and force them to break the law or else they're facing jail time. So we should view this all as a mechanism through which they are centralizing power, taking power away from any agencies. You even hear them saying they're against the whole idea of independent agencies, but here it even says you may not follow the law or else you are facing jail time. So that's what he did last time, and that's what he says he's going to do this time, and his executive orders this time are the beginning. And what's so tough here is, just as with the last one, it seemed innocuous at first. That language, oh, we're just making sure we're going to do the right thing. That innocuous language was giving cover to a profoundly corrupt action, to forcing a foreign country to do a sham investigation into your political opponent, or else we're threatening your literal safety, right? Because you're not going to get your Javelin missiles for your neighbor which wants to invade you.
And from a legal perspective, not just the safety of Ukraine, but policy as dictated by Congress,
Yes.
which had the authority
That's
to
right.
issue that in the first place. Yeah.
Yeah, that's right. This was profoundly illegal. GAO, in its responsibility said, yes, this is very illegal. I get some good quotes on it. They say an Appropriations Act is a law like any other. Therefore, unless the Congress has enacted a law providing otherwise, the president must take care to ensure that appropriations are prudently obligated during their period of availability. The Constitution grants the president no unilateral authority to withhold funds from obligation, right? That's straight from GAO's ruling that said the president, did the wrong thing. And I'll just say while we're at it, they ruled on just the illegal pause, but he actually paused so long. I mentioned that DOD said, hey, we're going to run out of time. They ran out of time. They literally ran out of time. They got to the end. They had only used up some portion of it by the end of their period of availability. Congress had to extend the period of availability. It has to pass, even though it was illegal to not spend it, they've run out of time. So Congress had to pass a new law rescinding and reappropriating the unobligated balances to extend the period of availability so it could be used, right? That was like profoundly illegal.
Okay, so let me just kind of tie it up for the audience, because I really want to set up what just happened last week. What you're talking about is a twofold plan. The first is to centralize all power in the executive branch in the White House and not push any of it out into the agencies, and use the agencies as a policy tool, right? With that, and override any kind of institutional knowledge or legal understanding, right? That the agencies exist only as a policy arm of the president, through the OMB. And the second is that one of the things that which they want to have the power to do is to kind of seize the spending power from Congress. Congress will say, here's the budget, here's how we want you to spend the taxpayers' money. And that the president can say, no, that's not consonant with my political and policy preferences, so I'm not going to do what you want. And Russ Vought, his entire, shtick is to say, that is within the president's power. And his deputy, Mark Paoletta, who's a lawyer that we've spoken about here a lot, he's like Ginny Thomas's best friend. He has been chosen because he wants to take this fight to the Supreme Court. So, okay, that's kind of where we are, right?
Yeah, that's right. It is both taking power from the agencies and from Congress. It is all about centralizing it inside of the White House.
Great. Okay, so then let's talk about what happened last week.
So
another long pause.
Yeah, I mean,
and a woo.
We all knew that this was going to happen, but it's still frustrating. It's still tough to see it happen. So we had some day one executive orders that were in violation of the Impoundment Control Act. The Impoundment Control Act, as I said, it very clearly says you must spend the money, but it was not the reason. It's not the reason you have to spend the money. The court cases before that, right? I mean, the appropriations and authorizing laws are the reason you have to spend the money. What the Impoundment Control Act actually did was granted new power to the president. Russ Vought will say, oh, it's only because of this unconstitutional law that I can't do it. Law is unconstitutional, so I can do it. Wrong. It's all the actual, statutes that say that you can't do it. ICA comes along and says, actually, if you do want to impound, here are some special paths to doing it. So it sets up ways in which the president may legally rescind, get a fast track to rescinding unobligated balances, during which they're allowed to legally pause. Or if you don't even want to rescind, there are other reasons that you could legally pause. So on the day one executive orders, they were going that second route. Section 1012 of the Impoundment Control Act is all about if you want to try to pare back some unused money.
You, the
Section
president.
10, yeah, you, the president. And I'll just say it's a filibuster-proof method. And Trump actually tried that in April, in mid-2018. Through the Impoundment Control Act, he sent up a special message pursuant to Section 1012 of the Impoundment Control Act and said, Congress, please get rid of some of this budget authority, some of this funding. And during that time, I'm going to legally pause on this because I want you to get rid of it.
Can you, I'm sorry to interrupt, but can you give an example of what a legitimate use of that authority would look like? Like why would you want the president to have the power to do that?
Well,
not this president.
Yeah, sure. So this was all in the context of Nixon illegally impounding. But Congress is allowed to appropriate money, and then it's allowed to come back later and say, actually, I think we gave it a little bit too much money. let's take some back. You
Mm-hmm.
could imagine kind of a permanent law where you say, hey, starting next year, this law is going to do less, right? So if Congress wanted to, I don't support this, but if Congress wanted to, they could cut Medicaid benefits, and going forward that you do less. You could also have pots of money, right? Kind of definite amounts of budget authority. And let's say you gave $100 million that is good until it's used up. And let's say Congress has used half of it. And then you come along and you say, I don't, sorry, not Congress, the agency has used half of it. And Congress comes along and says, I don't really like what this is being used for. So I'm just going to peel back any of the unused bits, any of the unobligated balances. You saw some of this for COVID money, where we gave huge pots of money, and Congress then came and said, well, the pandemic's over, whatever, right? I mean, obviously it was a big contentious fight, but they pared back, they rescinded some of the unobligated balances.
Mm-hmm.
Because Nixon was going about and trying to impound, Congress would pass a budget, it would fund a whole bunch of different agencies and budget accounts and sub accounts, and he would say, cool, I only want to do half of that, or 75% or 90% of that. They said, well, if the president doesn't like it, then you can just propose to rescind it. And of course, Congress can always propose a new law, but this is a way in which the president transmits a special message. So it gets the president involved, right? How a bill becomes a law. Congress is supposed to be the one writing the law, and obviously the president is allowed to say, please write the law. But the special message is where the president will transmit to Congress saying, rescind these budget accounts, please. And in the meantime, while you're thinking about it, I am now legally allowed to pause doing this while you consider it. And extra, this is going to be a filibuster-proof path to doing it. So in the Senate, instead of needing 60, it's a 51 voter, just like with budget reconciliation. So Trump tried this in 2018. It didn't happen. But this is kind of a legitimate path to rescission. And that's kind of one path he could have taken, but chose not to.
Okay. But so let's talk about what happened on Monday and Tuesday of last week, which was that there were these two executive orders which said basically, F you, Congress, we're not spending this money. Am I correct?
That's right. And that was kind of a big, broad one. So there was one for the Unleashing Energy one that was, where they kind of called out IRA funds and AJA funds.
No, you got to say what IRA is.
Yeah, please. The Inflation Reduction Act, which was, oh my goodness, it did a lot of things. The Inflation Reduction Act did a giant and biggest investment in clean energy in U.S. history. It was offset by going after some pharma profits. So it was going to reduce kind of some Medicare costs. It also was offset by raising corporate taxes and by going after rich tax cheats. So yeah, it's great. It's a great bill. The original version BBB would have been even better, but
thanks, Joe Manchin.
This much slimmer version was still a huge net positive for the country. So there was that, and then there was the infrastructure law. I'm going to get AJ wrong. I'm going to have to look it up. It's Infrastructure Investment and Jobs Act, right? But that was the bipartisan infrastructure law. And so one of the executive orders said, we are going to pause all additional disbursements on that. That was kind of big because it not only said we're going to do an illegal deferral, but it also would cause the U.S., if you read it at its word, would cause the U.S. to breach its contracts, which is very illegal.
Okay. That's what I want to talk about. But give us 1 sec. We got to take one more ad break. Unless you guys are subscribers at patreon.com/lawandchaospod or lawandchaospod.com, in which case you do not get ad breaks ever. Awesome for you. Be right back, guys. And we're back. Okay, Bobby Kogan, explain to us how these executive orders are illegal and how the rubber is going to meet the road here. And is it just the one executive order that we talked about before the ad break, or is it two orders?
Yeah, there was also a foreign assistance one, which, folks have been talking about PEPFAR, which I don't know what PEPFAR stands for, but it's
presidential, right? It's the good thing, the one that George W. Bush did, which was to establish funding to fight AIDS in the third world, because it's a communicable disease and it doesn't stay in the third world, and because it's moral to fight communicable diseases. So that's one of the ones that's been in the news today, because I think Marco Rubio, little Marco, ordered basically a pause on all foreign aid funding to everybody but Israel and Egypt. Is that legal? Does that present an impoundment problem?
It is also an impoundment problem. And you actually saw on the day one order, Trump called out a 90-day pause on all foreign assistance. That he had some language about what I could dig it up, but he had some language about what foreign assistance he was talking about. But that's presumably where PEPFAR and a lot of the other stuff falls under. But both of these are illegal for the same reason. They both violate the Impoundment Control Act, and they both, if read as their words say, would cause us to breach our contracts. So I'll start with the latter one first, because it's kind of much easier, and then I'll get into the Impoundment Control Act. You're not allowed to violate your contracts. If you sign a contract, say if the United States government signs a contract saying we'll pay you this much at this time, if we don't do that, then we have violated contract law. That is illegal. And you will still actually get your money, because you will sue the United States government. And then the judgment fund will be like, yes, you're right. Here you go. Here's the money. Or it might get before then, right? A court might just say, hey, release the funds. But you will get your money one way or the other, because we are not allowed to just unilaterally renege on our contracts. So that one is very straightforward. But if you read the EOs, they both say pause disbursements. And that's the key one here. It doesn't say pause additional obligations, right? Remember when I read that footnote for the apportionment, it was all about pausing additional obligations. The EOs, either due to maliciousness or incompetence or God knows what, say pause disbursements. And that's the key, where it would say it's not just don't sign any new contracts. It also says don't give out the money even for existing contracts where the time has come to pay it.
Can I interrupt you and ask you, my understanding is that the pause on all of these disbursements is not only to kind of impose the president's priorities, as Rustvogt would term that, but what he wants to do is remove all language that refers to DEI. He wants to reassert the Mexico City policy, which basically refused to disperse any funds. I think this is what PEPFAR is being paused. Refused to disperse any foreign aid that mentions abortion, mentions gay people, mentions gender discrimination. That the pause is so that they can kind of de-wokeify all federal government grants and contracts. Is that your understanding of what's going on here?
Allegedly, that is what is going on. But regardless, you are not allowed to breach your contract. You are allowed to say,
even if it's woke.
Yeah, even if it's, you're not allowed to break the law, even if it's a woke law, right? You are allowed to say go. Well, you'd have to check your discretion under the law, right? Each authorizing statute will give you different discretion, but assuming they have the discretion, you are allowed to say going forward, no new contracts will be made that work this way, and instead they all have to work that way, assuming you have the discretion.
Right. Which they have done via executive order.
Yeah, but you are not allowed to say, hey, existing contracts where we have already signed something saying if you do this, then we will give you this money, and you have done it. You're not allowed to be like, oh, JK, I'm just not going to give you the money now because I don't like the policy anymore, right? We've already signed a contract. That's why that part of it is so illegal. The other part of it is the Impoundment Control Act. And so I mentioned there's the rescission path, which is Section 1012. There's also just the pause path, which is Section 1013. Since they didn't, if you read those EOs, they didn't say, hey, let's just rescind all the money. They just said, let's pause so we can do it the way we want. That means they're in the Section 1013 route of the Impoundment Control Act. And 1013 is short and easy. Section 1013 says, if you want to pause money, you transmit a special message that has these 6 pieces of information. And by the way, you are only allowed to do it for one of these 3 given reasons. They didn't send a special message. And even if they wanted to claim that the EO counted as a special message, it didn't have all the required pieces of information.
No, an EO is not a special message to Congress. Come on.
It's not a special message. But even if they thought it were, it didn't have all the information. But much more importantly, it wasn't one of the 3 legitimate reasons. Right? That's it, right?
And what are those 3 legitimate reasons, if you want to spell them out?
So, subsection B of Section 1013 of the Impoundment Control Act says, consistency with legislative policy. Deferrals shall be permissibly only, 1, to provide for contingencies, which they didn't do. They didn't say that was the reason.
And just so we're trying to, contingency would be something like it says you have to buy, 500 widgets and the widget manufacturer is out of business, right? Something like that.
Yeah, that's great. That's a great that would be a great reason. Or, civil unrest in the country, whatever, right? Like tons of legitimate contingencies.
There's a cargo ship stuck in the Panama Canal, right?
Not like the contract says pregnant persons.
Right, that's right. You're not allowed to say, but it's because I don't like abortion. Like that's not a contingency. Number two, you can do it to achieve savings made possible by or through changes in requirements or greater efficiency of operations.
Mm-hmm.
That seems like there's a lot of wiggle room in that.
There's more wiggle room there, but this one is really about like the key purpose there is about spending the money better. That is about spending the money better. It's not about not liking the policy.
Mm-hmm.
And then number three, as specifically provided by law. So if the law gave you wiggle room, then you are allowed to use the wiggle room. Then obviously you're allowed to. But that's it. Those are the three reasons. You could quibble about number two. I don't think, I'm not a lawyer, but I don't think number two fits based on the way that I understand these things to work. Regardless, he didn't transmit a special message. So this kind of gets us back to what he did last time, right? Last time he did a seemingly innocuous thing, but it ended up being malignant. There were paths to legally pause this money. He didn't take them, and instead he took the illegal option, seemingly to say, oh, I'm just going to make sure I like the policy, which again is not a legitimate reason. But,
I mean, don't you think a contingency is I'm trying to blackmail a foreign leader and it has to say secret? I don't think that you've thought this through, Bobby.
That's right. So those are two very clearly reasons that these things are illegal. There you go, right? Like they're illegal for two reasons. You're not allowed to violate your contracts, and you're not allowed to violate the Impoundment Control Act.
Mm-hmm.
Well, now let's parse those two things, right? Because one of the things we learned in the first Trump administration is he can do illegal shit, and if it does not give rise to a cause of action, if nobody has standing, right? And I'm thinking in particular, right, the emoluments cases, right? It's very, very clear the president can't accept money unless approved by Congress, and he accepted lots of money by, directing foreign dignitaries to only stay at his hotel and so forth. So you broke down two kinds of potential legal violations, right? The first is if the government breaches its contracts as a result of what Donald Trump says. And I get what the remedy is there, right? Because the kind of law that I practice, right? So government contractors who don't get paid have standing, they bring a lawsuit, they get paid. But what happens, you've talked repeatedly how the Impoundment Control Act essentially has imposed no consequences. And so, who would have standing? What would happen? How would one sue? How do we hold this guy accountable?
Sure. So the Impoundment Control Act grants GAO standing.
Mm-hmm.
Right. And just to clarify, GAO is the Government Accountability Office. It's a kind of a congressional organization. And as I recall, the last time when GAO said, hey, you can't steal all this money from Ukraine, that's illegal. The Trump organization said, like, whatever. Vote said, this is a partisan organization. It is not. It is basically, it's not Congressional Research Services, but it is a nonpartisan, totally balls and strikes organization, right? It's a research and reporting arm. Okay.
Yeah, that's right. GAO is a nonpartisan government agency. So GAO is granted standing. You'd have to talk to a lawyer about whether that would actually hold
every
up
day,
in
man. I
court.
talk to lawyers every day,
No, I
all
know.
day.
But I think it's a legitimate question, a legitimate worry that you'd say maybe Congress can't grant standing, right? Like my lawyer friends say that's kind of a real questionable thing. If not, then you have to kind of take the approach that happened under Nixon, where lots of times people don't have standing, but plenty of times people do have standing. So if you ought to have gotten a grant in this period of time, but you didn't because Congress paused, then you definitely, or I don't want to say definitely, then you might be able to have standing, right? If because of this money ends up lapsing, right, then you're much more likely to have standing because the whole issue was that money didn't get out. You're trying to find someone who ought to have gotten the money, but because of this pause, contracts weren't made, money didn't go out, that sort of thing. And I think there are real hurdles for some of the money.
Okay, so kind of let's brass tacks this. We're really talking about maybe three types of actions here, right? We're talking about suing under the impoundment of the infrastructure funds, which Trump is saying now he's making some weird noises about, like, I didn't mean all infrastructure funds, I meant Green New Deal funds. And Green New Deal is like a pie in the sky plan that never happened. So I'm not really sure what he's going to impound only under Green New Deal, which is a thing which exists, only aspirationally. And we're also talking about, the foreign aid, and we're talking about Congress's power being usurped. Who do you think are the plaintiffs in these various scenarios?
Yeah, as you say, it depends on kind of how broad he's actually going. To your point, he issued guidance saying only stuff in the Section 2 policy and Section 2, whatever green means. But if, for instance, he's doing highway trust fund money, which it doesn't seem like he's doing, it seemed like maybe he did a one day pause and then he opened that back up. But if they paused that, then any state or local government that was supposed to be getting that money and isn't, they have standing to sue, right? Because the law says they're supposed to get that money. Similarly, the Inflation Reduction Act kind of gave tons of pots of money for green investment. And if you did the contract pause, then all of a sudden, and then you're not getting money that you were owed under contract, then you have standing to sue. But theoretically, and I think this one's tougher, but theoretically, if in the pause, you end up getting harmed by virtue of the pause, again, that's kind of tougher to show. I got harmed because I had to wait 120 days or whatever. But if you can show that, then all of a sudden you have standing.
Yeah, so let me just, I think my understanding was that part of the money under this infrastructure plan was to, or under maybe the Green New Deal, was to develop a system of car chargers, nationwide, right? And that there was money that was allocated for that. Trump is, mad at electric cars for some reason, which is weird because his, BFF is Elon Musk. But he's mad at electric cars because they don't pollute enough. And so he wants to cancel the car chargers so that electric cars are non-feasible. Can he do that? And if he can't, does the contractor to build it have standing to sue? What are we looking at here?
I mean, you can always break the law, so you can do it illegally. You can't,
as we have learned.
Yeah, you can't legally do it. I don't know whether for the EV chargers, whether it's money to states to then dole out, or if it goes directly grants made with individual companies or whatever. So I'm not positive who's supposed to get the money and therefore who has the standing, but it was whoever was supposed to get it doled from the government and now didn't. They are the ones who have the legitimate claim because they have lost the money.
Okay. And the states also, as you said, will have standing to sue. I have a sort of a weird question. Maybe it's the final question. Does Congress have standing to sue if it's allocations? I mean, it's a sort of interesting question. I know you suggested that the Government Accountability Office might have standing, but they don't. I don't think that that's likely. But I do think, particularly if Congress changed hands in 2 years, would Congress have standing to sue to say, look, I mean, look, if the Impoundment Control Act has no enforcement mechanism, I mean, it must have some enforcement mechanism, right?
Well, you're supposed to impeach the president
That's not helpful.
No, but I know we're joking, but like they did the only reason, and you can look up the testimony or the stated stuff from Nixon's impeachment. The only reason they didn't include violating the Impoundment Control Act on his articles of impeachment is that they felt they had enough already. But otherwise, they would have looked at that.
Okay. But you don't think that Congress, which, does, as you said, set the budget, has standing to sue if it's violated?
I don't want to opine on that as a non-lawyer. I know Congress has brought suits against lots of stuff in the past. I don't have a good instinct on this one, so apologies.
Okay, but you do think, right, the electric car charger companies and the states, which are supposed to get money under this allocation, are going to...
Totally, yeah. Any of them. I mean, again, with the asterisk being, it's not actually 100% clear what money he's pausing because he was so unclear about what funds were being affected. But anyone who actually has their money paused, if they're harmed in that, will have standing.
Excellent.
Okay. Well, we have gotten a preview of what the Trump administration plans to argue when those suits happen, right? Which is that the Impoundment Control Act is unconstitutional. And Bobby, we stick around for a Patreon bonus where we can break down all of those legal arguments in detail for subscribers?
Of course.
Excellent.
Awesome.
Thank
you so much.
All right, guys. If you are a subscriber, stick around. And if not, we will be back on Friday.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.